be here shortly if he doesn't. Hey, Braden, how you doing? Good to see you in the chat.
So it looks like we have 14 attendees. Do you know how many are scheduled to be on the call?
No, I think we're gonna get started here. Yeah, we're gonna get started here now. I think it's pretty full. Good afternoon, everybody. My name is Attorney James Dillon. I am the Legal Redress Chair for the state of Indiana, and we have with us Attorney Anthony Ashton. Can you introduce yourself, sir?
Sure. I'm Anthony Ashton. I am the Director of Affirmative Litigation at the National Office.
Absolutely. So Attorney Ashton is graced us with his presence. He's going to give us an update on some cases that the NAACP has been involved in this year. I was an adjunct professor, but Attorney Ashton he was a full-time professor.
No. I was also an adjunct. I've just been an adjunct at a few different schools.
Yeah. So, but he has experience that I don't. So he's going to give us an overview of some legal terminology that's going to help us as we go through our presentation. So first, Attorney Ashton, I'm gonna give the floor to you. If you could go through the cases that the NAACP has been involved in the last year, and then give us that brief overview of legal terminology that's going to help us in our discussion this morning.
Well, you have on your screen some cases, and those are pretty easy. They've actually because this is last year's presentation, so you may have heard about them before. So what I'm going to do is rather than jumping back to then, I'm going to talk to you about 3 cases that we've been dealing with recently. One being, as some of you might know, at some point during the summer, it appeared that that the mail slowed down, and literally things that should have taken 2 or 3 days to get someplace were taking up to 10 days. You had the Postmaster General who was commissioning or decommissioning sorting machines, and things generally, the mail went much, much slower. Now, I think I won't get into the reasons why. I think we know the reasons why. But the lawsuit that was filed against the U.S. Post Office that caused the post office to have to make sure that as much mail as possible got through, with regard to the election, meaning that ballots had to be given top priority, that they had to stop decommissioning machines. There was something else that was done during the summer where, for example, I believe that one of the policies became that the post office could only fill one truck and go out for one delivery per day. And what the result of that was is that you can't fit all the mail that comes in one truck from any particular post office generally. And so what happened was that you had a backlog of mail literally sitting in bags at the post office. The NAACP was the head plaintiff in that case against the post office. Many states' attorneys general, and yes, that is how you say it, attorneys general, not attorney generals. Learned that a while ago, but many states joined in that. And it's one of the reasons why come election day 2020, that the post office was working very diligently. And I'd say, I by that, I don't mean that I think that there was anything with the individual postal workers. I think it was directives coming from the top. But they worked very hard to make sure that as much as possible, mail was delivered timely. It included the fact that in the couple of days before the election, there literally had to be sweeps of facilities where the post office had to gather up mail or gather up ballots because the envelopes looked different and make sure that they went out. So that was an NAACP case. We didn't necessarily get as much press on it as we probably should have, but that was a big case that we took on. Another case that was just decided this week, which you'll may hear more about, is that Bike Week, which is it's where motorcyclists go down to Myrtle Beach, South Carolina. NAACP down there filed a lawsuit against the city to basically complain that the way that they were treated, the traffic patterns, all the restrictions that were put in place based upon race. The court, in fact, the jury, in fact, did in fact find that that race was a motivating factor. Now, didn't get the relief that we wanted, but the jury did in fact find that race was a motivating factor in the city's behavior. As far as some basic terminology, I'm going to basically say that there's a difference between state court and federal court. For federal court, you have to have a federal cause of action, meaning it has to be based upon a federal statute or the U.S. Constitution. Whereas for state court, you can bring actions based upon the federal Constitution in state court, but that's typically for more state matters. The other thing that you've probably heard a lot about in the news recently is something called standing. And as a matter of fact, the NAACP intervened in a number of the post-election cases or filed amicus briefs, and an amicus means friend. So a friend of the court briefs to advise the court on what the proper decision should be. Standing means that you have been personally harmed, meaning that you have the right to sue. And so anytime the NAACP or anyone else looks to file a lawsuit, typically what we want to do is we want to make sure that we have a right to sue, that there is some specific harm that has been experienced by either an NAACP member or by the association because of its goal and because of what it does. So, for example, the case that big case yesterday that you probably have heard the results of with the Supreme Court, where Texas decided it was going to sue the Georgia, Michigan,
Pennsylvania.
What was the fourth state?
Georgia, Michigan, Pennsylvania, Wisconsin.
Wisconsin, yes, where it decided it was going to sue those 4 states because it said that their elections had been done incorrectly, blah, blah, blah. Anyway, the long and short of it is it got to the Supreme Court. The Supreme Court looked at it and in throwing the case out, said, Texas, you have no standing. You have not been harmed. Meaning you have no right to be here. And as a matter of fact, of the 9 justices, 7 of them agreed with that and just said they wouldn't even allow Texas to move forward with the complaint. The 2 who dissented, the dissent, and a dissent just means that we disagree with the holding, with the basis of the ruling. Even the dissent in that case, which I think was Alito and Thomas, they said, we don't think we have discretion. We have to allow you to we believe we have to allow you to bring the case. But they did go one step forward and said, but we would also deny you any relief. Meaning that even the 2 that said that you had a right, that Texas had a right to be there, said you still weren't going to get anything. So those are the things that we look for when the NAACP files cases. We want to look and see what jurisdiction we're going to be in. We want to make sure that we have standing, meaning that we can show that there's some actual specific harm that's been experienced by either the individual or the NAACP as an association, so that we can get some type of redress, a remedy from the court.
All right.
And turn it back over to you.
Absolutely. Thank you, Attorney Ashton. So the rest of this presentation, and if you have any questions, please feel free to put them in the chat. We are monitoring the chat, and if there's any questions for me or Attorney Ashton, we'll make sure we get to them. So we're going to go over how a legal redress committee should be formed and should be set up in each unit. A legal redress is one of the standing committees that should be in every unit, every state area conferences, branches, and prison branches. The chair of the legal redress committee is appointed by the president of the unit, and all members of the legal redress committee should be appointed by the president in consultation with the chair. Like every other committee, it has to have at least 3 members on it. Here's what the legal redress committee does. 1, it investigates all claims reported to it. So anytime somebody sends a claim to the legal redress committee, it needs to investigate the claim. 2, it supervises all litigation in which the unit is interested. And 3, it keeps the national office and the unit informed of the progress of every case. So there's not a lot of litigation currently going on in the state of Indiana, but if there were, and if there were with any of your branches, your legal redress committee would be the point person or the point committee to keep both sides, up and below it, the branch and nationals informed on what's going on with each case. It needs to also advise the executive committee regarding the unit's activities that have to do with legal discrimination of a legal dimensions. All right, this is important. Under no circumstances should the unit legal redress committee give legal advice to any person or entity, but it may, upon investigation of a matter, refer any person or entity seeking legal advice to attorneys who have expressed a willingness to receive such referrals from the unit. So up in Gary, where I'm at, we have a few attorneys, and I know they have the same thing down in Indianapolis. We have a few attorneys that have agreed to take referrals, where if the legal redress committee feels that there's something there, after doing an investigation, if the legal redress feels that there's something there, they'll refer the case out, and then the attorney will make the determination, 1, whether or not they believe there's a case, and 2, whether or not they're going to file it. Sometimes they file a case, sometimes they don't. a lot of our legal redress chairs and committees in the state don't have an attorney on them. So sometimes when you get to a case, like Attorney Ashton was saying, there's no standing. There's no cause of action. There's nothing there. And when an attorney takes a look at it, he may say, you know, it's not necessarily right what has happened in this case, but there's not necessarily anything illegal or anything improper or any discrimination. Or if there is, it's not such that it's something that can be proven. Our state president just popped on. I just want to say good morning, good afternoon to her, Attorney Barbara Boland-Williams. And so, yeah.
I just wanted to throw in quickly, and for those committees that have an attorney on this and have an attorney on them, and it's very important about not giving any legal advice, because in a number of states, the determination of whether an attorney-client privilege or an attorney-client relationship has been created is judged from the eyes of the would-be client. So if you start saying, well, you've got a great case here, or you know, here's what, when you start doing that, and let's say you're not right, but they may actually think, I've got an attorney, I spoke to an attorney and he told me I've got a great case, and not do anything else about it and think that you're going to be doing it, that you're going to take it over. All right. And so the idea is that we don't want you to cause any potential liability for yourself or for the association.
Absolutely. Especially if you're an attorney. And you guys have been doing a good job with this. I will say, I don't see President Scully on here, but I know LaPorte County, we've worked with them a lot over the last year, and they've been doing a good job there. So methods of the work. This is what we do on the committee. Complaints are able, compliant units are able to use legal action as a direct action to achieve the goals. So these are things that require the national office's authorization. So you would be writing an email to Attorney Ashton, and then they would be having a meeting there, and they would be deciding if this is an appropriate instance for direct action. Of course, our direct actions are agitation, demonstration, marches, picketing, boycotts, and economic sanctions, and also can be litigation. And as Attorney Ashton was speaking about earlier, some things that he's been doing for the association, filing amicus briefs, friends of the court briefs to help the court understand, what should be done in these cases.
And I just say, as far as the all the other actions, yes, you want to talk with your state president, and can contact with the it's called OGC, the Office of General Counsel, to let them know if there are any of those actions that you would like to take. And again, it's about being, we want to make sure that the association, if the association is going to do something, it wants to make sure it knows that there are people out there saying, this is what the NAACP is doing. So that's why it's important to keep folks abreast, and it's important to ask for authorization before you pick up a picket sign and say the NAACP is going to shut you down. Make sure that the NAACP is in on it.
Yeah. Right. So I think what Attorney Ashton said is very telling, and everybody on this presentation knows that we are the oldest, the boldest, the biggest, and the baddest civil rights organization in the world, and you don't get to be that way without being deliberate. And so it's very important that we follow these rules. Sometimes navigating the NAACP can feel like navigating a bureaucracy, but that's because that's what it takes to be the biggest and the most effective and the longest lasting organization. That's what it takes. So it's very important that we follow these things. So the methodology that we use, and these methods are found in Article 2, Section 2 of our, it's blue this time, our blue book. It used to be the yellow book. And it says, states, there's 4 different methods. That's direct action, litigation, legislation, and political action. So the lower 2, legislation and political action, those really aren't things that come from the Legal Redress Committee. They come from the Political Action Committee and from good people like Hillary Shelton. But direct action and litigation are things that are the two methods that the Legal Redress Committee often use. And this is how we do the work. So proactive local advocacy. So the branches I've worked with over the last 2 years since I've been in this position, I will say ones like, we'll talk about LaPorte County and Michigan City branch with West Scully, because I've done the most with them because they've reached out the most to me. And I think one of the things that they do there is they get really involved in cases where they feel there's been discrimination. Most of their cases that they feel they've been discrimination with in LaPorte County have been criminal cases. Now, we're not defense attorneys, and they're not defense attorneys, and there's a prosecutor there. So, but what they've been able to do, and I've been really impressed with what their unit has been able to do, is that they do their investigation, they document their investigation, and then they always send their investigation to the court. They almost file an amicus brief at a trial court level. And it's not ex parte communication because they're not a party. So it's not like one party speaking to the court out of turn. And because it's us, because it's NAACP, the courts listen. And that's one thing that our name carries. Our name carries some weight. So we've seen instances there in the last year where juvenile cases that were going to be waived from juvenile to adult court haven't been waived. We've seen instances where cases, that were set for no bond has been granted, and a lot of it has been due to the investigations done by the LaPorte County and the Michigan City branch, and them filing their investigations with the court. So that's one way. That's proactive legal advocacy that they've been doing, and that's a good. Well, that's actually reactive legal advocacy, but that's really something good that they've been doing. So some of the things that are on the proactive side is a notice to stores when there's some type of alleged discrimination. The example given here is that there's better produce in the white areas than in the black areas, lack of sidewalks in certain areas of town, policies that hinder.
I think it's supposed to be driver, but
I do too.
I don't know.
Yeah.
But yeah, and there is something to be said for the clout of the name, and the fact that I remember years ago we were trying to get in touch with the governor of Alabama, and trying to see who knew him, and personally, and I remember speaking to somebody in a high position. It's the governor of Alabama. When the NAACP calls, he has to answer the phone. All right. So there is something about a letter to a business from the NAACP, an official letterhead, where what has been or when the wrong is being spelled out, and when the relief that you're seeking is being put forth in terms where the business owner knows people are watching, and this could have serious repercussions if I don't do what's right. And a lot of times it really is about doing what's right. And a lot of times it is about when people think nobody's looking at them, they will try to get away with things. When people realize that there's a lot of attention being drawn to them, most of them straighten up and fly right. Some still have to be, you got to knock on a little bit, but most people do the right thing once they realize that that there can be repercussions from their actions. What is the specific name of documents that are filed with the court reinvestigations? Also,
Okay.
You need to get permission from the president before filing.
So I would say, no, you don't. As far as what I was speaking of, and this is something that the LaPorte County, the Michigan City branch does, they just file what Wayne Fowler is the investigator out there that does it. He just files what it's labeled as in the court in our Odyssey system is a general motion, but what it is he files he calls it findings of the NAACP investigation, and you have to go to if you don't have an attorney to file it, you have to go to the clerk's office in your locality and find out exactly how they want it filed, because the entire state is on this Odyssey system. It's just e-filing, but the clerk should have a way for you to file if you're a non-attorney, because they always have to have access. No, you don't have to have permission from the state president to file it, because it's just I would say make sure you have permission from your branch president, but it's just the results of your investigation. So in the cases that Mr. Fowler filed his investigation, the report from his investigation, him and the president, Wes Scully, were working together on it. When the investigation was done, they wanted the court to be aware, because in both of these cases I'm speaking of, they wanted the court to be aware of what the investigation had found. And there's actually 3 cases that I know that they did it, and 2 of them were successful. One was not. One, the court looked at it and said that has nothing to do with us, and the court refused to hear it, or refused to consider that. And then we actually were able to still get the young lady. The young lady was sentenced to a very long sentence for her first offense. And me and our state president, Attorney Barbara Bowen Williams, were able to get her a modification of that sentence, where they cut some time off, but still that court was not interested in that investigation. So no, you don't need to have the state presidents. Just make sure that it's your unit president has approved it. We're not filing a lawsuit in this case. We're not taking any legal action in this case. All we're doing is advising the court of what the investigation that our legal redress committee has completed has done. That's all we're doing. And honestly, most of the time, because of the name, because of NAACP, the court's like, let me look at it. Let me look at it, just because, if I don't, it could be a problem. So I would say make sure you get your branch president's permission before filing it, and make sure your investigation is complete as well. That's the next slide. Make sure we have a good procedure for your investigation. And yes, put your Braden. I have your email address, Braden. I'll shoot you an email of this. But anybody who wants wants a copy of these slides, put your email in the chat, and I can get you a copy of these slides. Let me go to the next one. Okay, so this is what I was talking about. Investigating cases based on a complaint. You got to have a process, a standardized intake process. So the best branches have a form. Some branches don't have a specific form, but I would suggest you guys have a form. The Indianapolis branch has a form. The Gary branch has a form. If you don't, contact one of those branches. They'll let you see their form. It's a good form, and it has all these things on it: the name, email address, phone number, the entity alleged to have taken place, the date of the complaint, the description of the conduct, has all those things on there. You should do the same thing in every case where possible, because you want to follow a process.
And as far as dates are extremely important because of things called statutes of limitation. And in an employment context, there's also, I believe it's 100 days. Is it 100 or 300 days?
So for an employment in the state of Indiana, there's not a specific, it's not 100 or 300 days. It's 90 days from the time the EEOC gives you that notice of right to sue. You have to go to the EEOC, and there's not a, I think that I've been to the EEOC beyond 100 days. So it may be 300 days. So I have personally taken a case to the EEOC be more than 100 days after the incident has alleged to have occurred.
So I believe in it, and again, not trying to give legal advice, but then I'm going to say it's 300 days for a lot of employment actions in the federal context, which means that if someone comes to you and says, this happened to me this month, all right, well, write it down, get the dates on. And if you're going to work to conduct an investigation and to possibly pass them on to someone, always work expeditiously with the idea of, you don't necessarily know when the statute of limitation is if you're not a lawyer or if you don't look it up and you're not giving legal advice. But you don't want to have someone who said, this happened to me last year. They're close to the statute of limitations. And then you sit on it for a month and a half, because then their cause of action may simply become stale and evaporate. And you don't want to be in a situation where, even though you're not their lawyer, you don't want to be in a situation where they're looking at you as, hey, why didn't you tell me this earlier? All right, so you want to move quickly, but you also want to get that vital information down there. All right.
Yeah, and I would also say that just to make it plain, and this is complaints that I've seen from people who've come to legal redress committees for help. I think it's important to make it plain that even if you are a lawyer, that what you're offering is an investigation from the NAACP and not legal representation. If we refer it out to somebody that can do legal representation, that's down the line. If it's an action that we feel that we should take and we get permission to take it, that's again down the line. But at the initial stage, it's important that you let people know, we're offering an investigation. We're not offering you legal representation on your matter.
I think you got to go back one.
I think I missed that last one. So the unit might not be in a position to investigate immediately every complaint submitted to it or provide assistance in every case. I think it's important to let people know, if that's the case, that you're not going to be able to get to it. You know, if you only have, and a lot of our committees around the state only have the 3 people, and 2 of the 3 people are normally the branch president and the committee chair. So investigations can get a little complicated. If you can't handle it, make sure you let them know, listen, we can't handle it. If you need some help, make sure you give me a call. I will tell you, the last month or so, we had my son had COVID, had to quarantine for a while. But before that, because I've dealt with several committees throughout the state, helping them out if they needed some help. Can a broad remedy be achieved? You have to look at what in your investigation, what is your goals to the investigation? So will it help establish a new legal precedent? Can a broad remedy be achieved? Has a violation of a fundamental or constitutional right occurred? Will the violation go unaddressed, or will it be unlikely that the complaint is able to attain effective legal assistance absent our intervention? So I think the big thing is knowing what to get rid of.
Well, I'd say this. First of all, for my position, as far as being director of affirmative litigation, these are the items that I'm looking at in deciding what lawsuits should be brought on behalf of where the NAACP is the plaintiff, is the party bringing it, will it establish a new legal principle or protect an existing precedent, and will it have a broad effect? Because generally we want to bring, and we're looking to bring more cases that will have the effect of helping more people and changing the status quo. So those are things that we do look at. But by the same token, if someone comes to you and says, I don't like my neighbor doesn't like me, I think my neighbor's a racist.
Yeah.
Okay. James.
Yeah, that's what I was saying. Knowing what to get rid of. Every time somebody brings a complaint, it's not something we can help them out with. You know, the neighbor dispute, I don't like my neighbor, I don't like the way they look at me. That's not a dispute we can help them out with. I was talking to the Gary Branch president early last year, and one of their complaints was a guy who had literally been late for his job like 20 times in 2 months, and he got fired. And they're like, "This is racism." And it's like, no, you know, it might be, but you were late an awful lot.
But it's also lateism. Yeah.
Yeah. And so you got to know what it like. Sometimes we can't help, and sometimes even if it's an issue, it's not a civil rights issue. Nobody's fundamental or constitutional rights have been violated, and it's best maybe we tell them like, hey, maybe try the ACLU, or hey, you know, maybe try some local attorneys. But it's not something that we can look at. You'll save a lot of time looking at that.
I'll give you the last one on this, and then we'll move to the next slide. There's a musical called Hairspray. I know it because I live right outside, although I'm from Chicago, right now I live in Maryland, and I live right outside of Baltimore. It takes place in Baltimore. The big production number at the end, there's an interracial couple. In the movie, it's Amanda Bynes and an African-American boy. And she says, and if they try to break us up, we'll call the NAACP. And I'm looking at going, and what do you want us to do about it? All right, that's got nothing, that you would be amazed at what people say. I'm gonna call the NAACP. Okay, well, you can always call, but that doesn't mean that there's something we can do about it.
Absolutely. And so again, more on your investigation. Evidence gathering is essential. You'll be shocked at the companies that are willing to work with you. I can tell you that big companies, the steel mills, U.S. Steel up here, ArcelorMittal, the hospitals, all of them have sustained we've had complaints against, and most of them are absolutely willing to have you come in, to have you work with them, to say, hey, here's our policies, here's you know, some things that there's a few, you know, privacy things that they have to work around. But either way, most of them are more than willing, especially the larger companies. They don't want to be that company that doesn't work with the NAACP. So use that to your advantage, gather all the essential information. And again, we have no permanent friends and no permanent enemies, just permanent issues. And this is the hardest thing to navigate, because we have our freedom funds, our life member banquets. We have, you know, we are great at meet and greeting and eating. And some of these same companies that we may have complaints against, we're then going to go to in the spring and say, listen, our banquet's coming up. Would you like to sponsor a table? And it's important that you understand, everybody understands, that we have no permanent friends and no permanent enemies.
I say think of it as if you're riding on a train. It's a long train ride, or a long bus ride, or a long flight. You talk to the person next to you because you're both going to the same place. But chances are, once you leave that plane, you're not going to hang out with them on your trip. Okay. So look at it that way. And even if there's someone who they're doing one thing that may be disagreeable, that you're not going, that doesn't mean that everything they do is wrong. All right. So look at it that way, where we work with people when we can. We take on the issues that we need to take on. And at the end of the day, it's all about achieving the same goal, which is the ultimate end goal is equality, and to make sure that we're doing better as a people. And that doesn't mean that, you know, just because you happen to like that guy, or he was always nice to me, we would go to lunch. Okay, but things have changed. Okay. And
then you got to look at both sides. It's a real investigation. Like I said, sometimes it's not like Attorney Ashton, it's not racism, it's lateism. You know, sometimes there's other reasons why things happen, and it doesn't have to do with race. You know, sometimes Black people find themselves on the short end of the stick, or people of color find themselves on the short end of the stick, and sometimes it's not because of the color of our skin. Sometimes it's because of other reasons. So it's very important that we look at both sides. If we're going to have a real investigation, we look at both sides. If it's completely one-sided, when President Scully and Mr. Fowler go to file that brief with the court, or go to talk to the judge about it, the judge isn't going to look at it. He's going to say, listen, I could have heard this from the defense attorney. So it's very important that we have a have a two-sided approach to our investigations. Helpful questions. What really happened? What's the other side of the story? Did a legal violation occur? Did a civil rights violation occur? Does the violation merit a remedy, or would investigation be beneficial? Have you attempted to resolve your dispute through negotiation? This is what I'll say. One, the last one, have you attempted to resolve your dispute through negotiation? A lot of our big companies are willing to sit down and talk about it, especially on an employment law issue. They're willing to sit down and talk about it. Yeah, that's what I've seen. Does a violation merit a remedy that would and would litigation be beneficial? Sometimes it's a minor offense. If it's not an employment violation, sometimes it's a minor thing, and an apology may be all it takes. The value of a case. Civil rights is a different beast, but if you're dealing with other type of actions, the value of the case often has to do with the damages that the plaintiff has incurred, and you haven't been really damaged, and apology.
They asked the question, what if the other side doesn't want to negotiate? Okay, negotiations are like arguments. You can't argue with someone who won't argue back against you, and you can't negotiate with someone who won't negotiate back against you. If someone says, I'm not going to meet with you, I'm not going to talk to you, well, then they are foreclosing negotiations. They're saying, I'm going to fight you. And the only way you're going to get anything done is to fight. All right. And then that's when litigation might be necessary.
Yep.
I mean, the person who contacts the individual. Oh, you mean if the person who has asked us for help says, I won't negotiate with the other side. Okay.
Then they're looking for a law firm.
Yeah, they need a lawyer.
Yeah.
Because they've decided they just want to fight. All right. And they also need to be aware, and their lawyer can explain to them, that litigation is the most expensive way to get something done. It just is. And quite honestly, the truth is, if there's something to be said about what we were taught back in kindergarten and first grade, if you bump into someone or if you step on someone's foot, say, I'm sorry. You would be surprised at how much can get done with an I'm sorry, or you're correct. You were right. I was wrong. All right. We entrenching ourselves, which is something that we become more and more prolific. Just end up in arguments. I look at it as the Facebook principle. Doesn't matter how much you yell at somebody on Facebook. They're not going to change their mind.
No. Yeah, I that's what they're looking for. If they don't want to negotiate, yeah, it's best that you send them away, send them on their way to find legal advice. In your investigations, make sure you keep the records of each complaint, what you did. Also, in case anything comes up, especially if you have a lawyer on your committee, make sure you keep names, addresses, telephone numbers, everything, because if you have a lawyer on your committee and there's a complaint, there is a chance that the complaint could make it to whatever body is over discipline in that state. So make sure, for the people serving, one, for good record keeping purposes, in case it does lead to litigation, but just to protect the people on your committee as well. Make sure you keep a good record of your investigation, what happened in your investigation, all the information, everybody's number. Make sure you keep a good record of all those things.
I'll say two things and make sure up later. One, don't ever take anyone's original documents. If they say, I've got this, don't accept original documents. A copy is one thing, but if it's the only one they've got, you do not want to be responsible for that. Two, as far as keeping track of the disposition, meaning do some follow-up, because the worst thing is to say, oh yeah, they came in and we took a look at it and say, oh yeah, so what happened? I don't know. That you don't want to be in a position where when asked, well, what was the ultimate outcome? And your response is, I have no idea, I didn't follow up.
Yeah. So that's make sure we keep those records. Now, if it's determined after your investigation that some direct action, we're just going to go through this, and this is the same for any committee that would determine that there was a direct action needed, but we're going to go through it. And since we have somebody from the OGC's office here, that's he's going to make sure I'm not misleading you on any of these things. If it's determined by the branch that we need to take an action on it, then these are the steps that need to happen. First off, you got to do some legwork. If your direct action is going to be a march, a walk, and any type of sit-in, die-in, lay-in, or whatever the current term for it is going to be, you need to make sure you include with your application all of the necessary requirements for permits, for signage, for marshals, for anything like that that are often included in local ordinances to do a march or to do a rally or something like that. Make sure you know it and you include it so that the Office of General Counsel doesn't have to look for it. Likely they'll just say, go back and find it, and that'll cause a delay in your direct action. Then you send the form to the Office of General Counsel. That form needs to be done at least 15 days prior to your event, and there is a fee for insurance, $125 fee for a certificate for insurance. Well, that's a certificate of insurance that we need to submit. Again, we want to make sure that the branch and the NAACP is properly protected in case something happens. Actually, I have a question since you're on here, Attorney Ashton. I know you weren't quite with the NAACP in your capacity this spring. There were a lot of direct actions this spring. I mean, tons of direct action. Do you know if the Office of General Counsel was involved in those, and were there any complaints or litigations to rise out of any of those direct actions?
I have not been informed of any. I'd say there's a number of different organizations, different departments. So this is purely for the legal part. But as far as coordinating, as far as working with field operations or comms or something like that, they have their own departments to figure out, as far as how it's going to be publicized and what message should go out. So these are literally the legal forms that you need to do. And I wanted to say this about the 15-day prior to the event. Everybody on this call at some point was in high school, where at the beginning of this semester, the teacher gave you the entire syllabus and said, okay, your final report is going to be due on X date. You could finish it months ahead of time if you wanted. You don't have to wait until the final date to turn it in. And I'd say that about the 15 days prior to the event. If you
Was that me who froze or Attorney Ashton? I can't tell. Yeah, that was Attorney Ashton. Okay. So what he was just saying is, prior planning prevents poor performance, and it helps everybody out. So I'm sure he'll reboot in a second. But yeah, make sure you get those in as soon as possible. As soon as you know there's going to be an action, things you want to avoid, and I'm going to power through this kind of quickly because we're running out of time and we got a few slides left. Defamation. Speaking bad, you back, Attorney Ashton?
Yes.
Okay, you're back. Yeah, I was just telling them, make sure you get it in as early as possible, prior planning.
Thank you.
For performance. So things we want to prevent, and this is to protect the unit, the branch, and the speaker. Defamation. The unit, the branch, and the speaker can be sued. So don't say anything that's not true. Libel, slander. Don't write anything that's not true. Go ahead, Attorney Ashton.
And true means I can prove it, okay? There has been a tendency for folks to say, well, everybody knows it. No, everyone does not know it, all right? Some name calling is not defamation, but other name calling is. That guy's been stealing from the state for such and such amount of years. That's what's called defamation per se.
You've accused
It
him.
is the legal definition of defamation. If you accuse someone of committing a crime, okay, and it doesn't matter what the crime is, if you accuse them of committing a crime, that's defamation, unless they've been convicted of it, in which case, then you can say convicted felon. But if you just know it in your heart of hearts, then keep it in your heart of hearts and don't let it come out of your mouth of mouth. All right.
Absolutely. Yeah. Yeah. Don't do that, because now, like I said, they can sue you, the branch, and the national for that. So please stay away from that. Be careful about making fake statements that are fact. Yeah. Don't do that.
And it doesn't become a fact because you followed up with, and everybody knows it.
Yeah.
That doesn't mean anything.
I think Attorney Ashton covered this. Avoid accusing someone of doing something. Avoid accusing someone of being dishonest or unethical. Avoid speaking ill of an individual when complaining about the complaint. Avoid speaking off the cuff. Have something prepared. So I was an undergrad. I was a philosophy major, and an attack on character is a legal fallacy. When you attack somebody on something other than the issue that you're dealing with, it's a fallacy. So let's stick to our issues. If our issues are workplace discrimination, if we're dealing with a grocery store, the produce and unfair pricing, and whatever our issue is, let's stick to our issues. And not only that, if we stick to our issues and we don't attack the person, we're more likely to be able to work something out. We're more likely, if we are sticking to our issues and we're not blatantly attacking the person, then I think we're much more likely to be able to get something out of this. Let me take these two questions, because
there's a couple of questions, and while you're looking at them, I'm going to say this. There's something about the difference between something that's in writing in a pleading versus something that you say outside of a pleading. If a lawyer writes in a pleading, this person committed these acts, that's a pleading. And because it's before the court, there's immunity for it, meaning that there's a privilege that comes along with it. If that same lawyer were to stand on the courthouse steps outside and say the same things, that lawyer could be sued. All right. And that's why typically when you may see something in the news where they said they referred us to the pleadings, it's because they don't want to be accused of defamation. So they're saying, you can look at what we've already filed.
Yeah.
And go ahead and take your question.
So Ms. Smiley asked a question, and Deborah Smiley asked a question about how do you suggest attorneys be involved in this? I know I'm involved in a committee. Taiwan Newsom down in Indianapolis is involved in the Indianapolis branches committee. Both of us are attorneys, and here's what I do. I'll just tell you what I do. One, I add a little bit more on my malpractice, so I pay for malpractice. And there's a thing you can add on for being a director and things like that for a nonprofit, and it's kind of under that. And so what I do each year, I talk to my provider about it, and I ask them what do I need, and they add something on, and I take care of it that way. Two, I make sure everybody I talk to that in the capacity as legal redress chair understands I am not your attorney. I am not your attorney. I am a volunteer for the NAACP, and I'm going to work on this investigation because I believe in the ideals of this association. And if something comes of it, it'll come through the NAACP. So that's how I do it. I would encourage attorneys absolutely to be involved in these committees, because attorneys can help weed through a lot of stuff that is just not appropriate for this committee, maybe appropriate for political action or something else. Something from this committee. And President Ratcliffe pointed out that Roderick is a member, and Erica Bryant is also a member of the committees. Absolutely be involved. I encourage attorneys to be involved. You just got to protect yourself as you would if you were involved in any other nonprofit.
Now,
What
someone mentioned social media, so I'm not going to give you legal advice on if someone's attacking your family, but I will say this to all of you who to keep this in mind. Just because it's on Facebook or Twitter or Instagram or any other social media doesn't mean it's not defamation. It's, in fact, you put it in writing, it's libel. I can tell you now, I was in private practice for more than 20 years. And one of my last cases that I had was a defamation case where someone decided that they were angry at the guy who ran their gym. And so decided was going to write some nasty and untrue things on social media. And that person got sued. So when you're going to write anything, if you're typing it into any type of medium, it can still be liable. The only thing needed for a libel is that you make a false statement about someone that would cause people to look at them with disdain or in a worse light, and it causes damages to them. Now, it's different if you're a public figure. There's a little bit more to that, but when you're talking about, oh, this is the supervisor at a job, make sure that you do not do anything that can land you in trouble, and especially don't do it while you're wearing a shirt that says NAACP and it says, well, the NAACP says you're a thief. Okay, no, we don't. That's all you, and you have to distinguish yourself in your individual capacity from being a representative of the organization. But I will tell you, whenever you walk out the door and you're wearing paraphernalia, whenever you present yourself as a member of the NAACP before you speak, you're going to be seen by the public as speaking on behalf of the NAACP. And it's important that you think before you speak. And that's one of the reasons that you don't speak off the cuff. Have prepared remarks. And if there is nothing wrong with when someone asks you a question, particularly if it's an inflammatory question, saying, that's not what we're here for, or I'm not going to address that. Those are perfectly acceptable responses.
Yeah. We've been given our time check. We have less than 5 minutes left. So
all right, let's start rolling.
We'll see what else we got. Litigation, legal action. We've talked about these. It requires authority from the president, CEO, and the general counsel. So the NAACP is not suing anybody on your behalf unless it goes up to our general counsel and Mr. Derek Johnson, period.
Yes.
So just remember that. We're going to breeze through those. Unit-based NAACP. Units can file amicus briefs, and units can intervene. Again, still, Office of General Counsel needs to be advised. Board of Directors or President Derek Johnson will likely need to also sign off on those. These are just examples of cases where units have been involved. I'm going to send these out in the slides. Outside organization, if any outside attorney or organization offers to represent your unit in litigation or provide assistance in the case, immediately refer them to the Office of General Counsel. We got to follow these rules to protect everything, to protect everybody and everything. And
I will tell you, the faster you do it, the better. The more lead time, the better. I've had people that that have sent stuff to the Office of General Counsel where they said, "Oh, well, we want to file a brief tomorrow." Okay, well, then you should have contacted us last week. It's not like you decided you were going to file this brief today, and it has to go through a long chain. Now, yes, we have moved very quickly with regard to the post-election lawsuits, but we also had a huge team working on that, and we knew they were coming. All right.
I'm gonna wrap it up because our time is up. But I will say this: I'm gonna email out everybody who put that in. Attorney Ashton, the NAACP email that I have for you, is it all right if I share that in the email that I send people with the slides?
Sure.
Okay. So my email will be there. Attorney Ashton's email will be there. If you guys have any questions, send them to me, and we'll get them done. If you have any questions, you can also send them to Attorney Ashton, and if he may refer them back to me, or or I may refer them to somebody else. So thank you guys very much for attending, all of our 28 participants.
And he
give it up,
give it up for attorney. He did very well for a Kappa.
Oh, wow. Yes, absolutely. Kappas achieve at everything, and Alpha should know that. But please, Frontline, if you guys can send me everybody's the chat so I can make sure I have everybody's email, that'd be great. All right. Thank you very much, everybody. How do I pause share?